everyone. In the last class, we have started discussing regarding the contract of the indemnity and proceeding to the remaining sections. We have started with section 124, chapter 8, which speaks about the contract of the indemnity. So, under that circumstances, we have read about the section 124, which speaks about that a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of the indemnity. So, moreover, under section 124, we have discussed that when there is one party who is assuring the other party to indemnify or to pay the damages of the losses which is been caused by himself, by the promiser, or by any other person. For example, I am promising you that I will pay you the losses that is either occurred by me or by any other person. Okay, maybe the other person, that person may be my relative or related to me, or may not be, that person is related to me. But if I am taking the responsibility or I am doing the contract of the indemnity to pay you the damages or the losses which is occurred due to me, then I have the responsibility and I must do the payment of that. Okay. Next, under section 125, we have discussed about the rights of the indemnity holder when sued. So, under section 125, we had discussed about the rights of the indemnity holder. And under that also, I have already explained there are certain rights of the indemnity holder. So, what are those rights? Let's have a look on that. So, what does it exactly speaks? The promisee in a contract of the indemnity, acting within the scope of his authority, is entitled to recover from the promiser. What does it speak? It speaks that when there is the presence of a promisee, the promisee in a contract of the indemnity, when there is the contract been made for the indemnity or to pay the damages, in that case, the promisee in a contract of the indemnity who is acting within the scope of his authority, the promisee which is acting in the scope within the scope of his authority is entitled to recover from the promiser. The promisee is entitled to recover from the promiser. So, what exactly the promisee is entitled to recover? Point number one, the damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnity applies. So, what is the first point speaks? The first point speaks that the promisee is entitled to recover from the promiser. Firstly, the all the damages which he may be compelled to pay in any suit in respect of any matter to which the promise of indemnity applies. For example, I have done a promise, I am the promisor over here, and I have done the promise of the indemnity to the promisee to you. Okay. So when I am not performing my part of the promise or I am unable to do my performance in the contract, so in that part, you are filing a suit against me in the court of law. So when you are filing a suit against me in the court of law, in that case, there are certain expenses of the suit which you are bound to pay, you are compelled to pay the damages. Okay. The damages which we may be compelled to pay in any suit in respect of the matter in which the promise of the indemnity applies. That means the damages or the losses which has caused to him for which the suit has been done. Those damages must need to be paid by the promiser himself. The second point, all cost which he may be compelled to pay in any such suit, if in bringing or defending he did not contravene the orders of the promiser and acted as it would have been prudent for him to act in the absence of any contract of the indemnity, and the promiser authorized him to bring or defend the suit. In the second point, it exactly speaks that all the cost, that means whatever there is the cost of the suit, that means if there is any suit or any of the procedure is happening in the court of law, so there must be certain expenses of the court that is required, like the fees of the lawyer, the court proceeding, the paperwork, that all needs money. You cannot do the all the proceedings without giving a single penny. Okay, so you have to pay for all these procedures, right? So when you are paying for the court procedure as the promisee, okay, and as the indemnity holder, then you have the right to recover your payment or the debt or the amount you are expensing in the court proceedings in the suit itself from the promiser itself. Okay, that is the second thing. And the third point, all sums which he may have paid under the terms of compromise of any suit, if the suit is getting compromised. There are certain proceedings for the compromise which we have already discussed. Maybe there are the arbitration procedure, there is the conciliation, there is the mediation, there is the negotiation. There are different kind of the activities through which the compromise can be done. So if in a suit the compromise is being done, the compromise of the suit is being happening, then in that specific circumstances, in that case, when there is a compromise between the parties, and if the promisee has done his expenses for the compromise of the suit, okay, and the promisee is liable to get the amount from the promiser, but the promiser has not paid it, that is why the promisee has to go for the court proceedings and then to compromise. So in all these cases, the promiser is liable to pay not only the damages which he has promised to pay before, but also he is liable to pay the expenses of the court fee, the expenses of the court, and as well as the if there is any compromise happening, the fee or the money which is getting done through the compromise process. Okay, next, section 126, it speaks about the contract of the guarantee, surety, principal, debtor and creditor. So what are these things? Let's understand it in a detailed manner. The first point, a contract of the guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. So, contract of guarantee means, for example, there is a promise between the two parties. Okay, for example, I have taken the debt amount of 3000 rupees from you. Okay, so when I am taking the amount of 3000 as debt from you, at that moment, I am promising you that I will repay the debt in between 2 months. Okay, 2 महीने के अंदर मैं आपको repayment कर दूंगी. I am promising you that. Okay. So in certain circumstances, what is contract of the guarantee? That you know that I am not a person who usually does this payment on time. That is why you are not assured about the repayment of the specific debt. That is why you are not trusting me. You are telling me that what if you will take my money and go away somewhere? So how can I assure you? So here I am guaranteeing the payment through a surety. Surety is a newly introduced word over here. The surety means the person who is giving the surety, who is giving the assurance. Surety means किसी बात का भरोसा दिलाना कि हाँ अगर ये नहीं करता है तो मैं कर दूंगा. So this is called the surety. So when I am appointing a surety on behalf of me, that makes the contract more trustworthy, because here what I am doing, I am promising you that I will pay you the amount of 3000 rupees in between 2 months. But you are not trusting me for the contract. So here comes the contract of the guarantee. जहाँ पे अगर आप मुझे trust नहीं कर रहे हो, then I am doing a contract of guarantee. With whom? With the surety, with the third person. For example, that person is my friend, my colleague, my relative, any other person, anyone I wish to bring as the surety. That person is uh, appointed as the surety on behalf of me. That yes, I am being the surety of this person. If this person is unable to pay the amount of 3000 rupees on time before 2 months, then I am taking the responsibility to do the payment at any cost. That means the surety is giving the assurance that if the payment is been not paid in between the particular duration of the time period, then the payment will be paid by the third person, by himself, by the surety itself. That is called the contract of the guarantee. Contract of the guarantee means here the surety is guaranteeing the creditor that yes, if the payment is not done by the principal debtor, then I am here to do the payment of the rest. Okay. So who is the surety? I have already explained you. What is the contract of guarantee? I have explained you. Then comes the principal debtor and creditor. Creditor is the person who pays, who gives the, for example, you have taken the rent of my home. So I am the creditor over here. You have taken the debt or money, the amount of 5000 rupees from me. Here I am also a creditor over here. And when we are talking about the debtor, principal debtor means the person who has taken the debt or on whose behalf the contract of the guarantee has been done. That means, for example, here as I have explained you that uh, I am I have taken the amount of 3000 rupees from you. Okay. So here when I have taken the amount of 3000 rupees from you, that I became the principal debtor over here. I am the person who is the principal target of yours, to whom you can sue at first if the payment is not done in between 2 months. If I am unable to do the payment, then who will pay? My surety will pay. Okay. But before that, who is the debtor over here? Who is the person who has taken the debt from me? That is me. Got it? So the person who takes the debt, who is the primary person on whose behalf the agreement of the payment has been done, the agreement of the surety has been done, that person is called the principal debtor, and the person who gives the money, that person is called the creditor. Okay. And the person to whom the guarantee has been given, that means if I am the person to whom the guarantee has been given, that yes, the payment must be paid to you. If the debtor is not paying, then I am going to do the payment. Then I am the creditor over here who has given the money or to whom the assurance or the surety has been given. Okay. Then comes section 127, which speaks about the consideration for guarantee. What does it speak? Anything done or any promise made for the benefit of the principal debtor may be sufficient consideration to the surety for giving his guarantee. Okay. So what does it mean? Anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. That how does it work? For example, for the benefit of the principal debtor, something is done or some promise is made. Okay, that is considered as the sufficient consideration to the surety for giving the guarantee. So how does it mean? Let me make you understand. For example, you have taken the amount of, one second, guys, I'm getting a call actually. Okay, so what I was talking about, yeah. So I was telling that anything paid or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. That means when there is the presence of the surety is giving any specific guarantee, then what is the proper consideration, sufficient consideration for the surety for giving the guarantee? That is, if anything made or any promise made or anything done for the benefit of the principal debtor. That means if there is any kind of benefit which has been done to the principal debtor, then that becomes the sufficient amount of sufficient consideration for the surety for giving the guarantee. So let us understand how does it works. Okay. For example, I have paid you the amount of 5,000 of the rupees. Okay. Or no, let's take a easy example of this. For example, I have given you my home. We have entered into an agreement that yes, I am going to transfer my property to you, my home to you. I am going to sell my home, okay? And I am going to sell the home with the amount of 50 lakhs of the rupees. So you have promised me as the principal debtor that yes, I am going to do the payment of the whole house, that is for the of the 50 lakh of the rupees. But I am not trusting you that you are going to do the whole payment to me. I have a doubt that what if you skip my money, what if you are not paying me, then what will I do? Then you are assuring me over there that ma'am, don't worry for this. If I am not paying for the rent for the house money, that is up to 50 lakh of the rupees, I hereby entering into an agreement with you that in absence of me, my surety, that is my brother, sister, father, uncle, whoever it is, that person is appointed as the surety over here. Even if I am unable to do the payment, that person will do the payment for sure. So here, that person is appointed as the surety of this. Okay. So here, the point is, I have done an agreement with you. Okay. The house belongs to you. Okay. I am buying the house belongs to me and I am selling the house to you. That you are buying the house with the amount of 50,000 of the rupees. So here I have done something for you. So what did I did? Either I promised to you that I will sell my home to you, or I have already sold my house to you. I have already transferred the document to your name. So this exactly speaks anything done or any promise made. If I am promising you that I am doing the transfer of the document, that in the next 2 months, all the uh, home of mine, all the property of mine will be automatically be with your name. So this is the promise made, which will happen for sure in the future performance, or anything done. For example, I have already sold my house to you, I have already transferred my home property to you. That is the thing that is called the anything done. Okay. So when anything done or any promise made for the benefit of the principal debtor, who is the principal debtor over here? You are the principal debtor over here, because I have the house which I have decided to sell, and I have already decided to transfer the house, and you have already said okay for this, that yes, you want to buy my house, and that is why I am doing the transfer over here of the property. So here I became the creditor, who is the crediting my property to you, who is giving my property to you, and you are here, you will be called as the principal debtor, who has either taken the debt from me or who has either taken any benefit from me. डेप्ट का बात तो छोड़िए, वो तो हो ही नहीं सकता, because I have not taken any debt from you. But yes, I have taken the property documents from you. That will be considered as a debt also. That is why you are over here will be called as the principal debtor, because you are the primary person who has rented my property or bought my property or taken part in the buying process of my property. Okay. So you will be called as the principal debtor over here, and I am the creditor over here. Okay. So when you are appointing a surety on behalf of you, that there is a surety, there is a third person who is appointed to give the assurance that in case you are doing the non-payment of the thing, then that person is going to do the payment. So what will be the sufficient consideration for the surety to do the payment? When the property is already transferred, or when there is the promise to transfer the property. In these two cases, this becomes the sufficient consideration for the third party, for the surety, to enter into the agreement of the surety and to do the payment of the surety in case the payment is not done. Okay, this is what we have discussed under section 127. The illustration sheet speaks that when there is the absence of the consideration, this kind of the agreement will be called as the void agreement. That is why the consideration must need to be present for the surety to enter into the contract of surety. If there is no consideration is present, even if the surety is giving its surety assurance, that will be considered as the void agreement. The consideration must need to be present. What is the consideration? Something must need to be done for the benefit of the principal debtor, or in other cases, some money must need to be transferred, or any promise must need to be made to the promiser, to the principal debtor, for his specific benefit. Got it? Next comes section 128. It exactly speaks about the surety's liability. So, what do you understand by the surety's liability? The liability of the surety is coextensive with that of the principal debtor unless it is otherwise provided by the content. So, what does it mean? The liability of the surety is coextensive with the principal debtor. It simultaneously or parallelly runs with the principal debtor unless it is otherwise provided by the content. If there is the specific agreement present over there, then it might be violated. But in otherwise, it parallelly or simultaneously runs with the liability of the principal debtor itself. That means, let's understand the illustration that is mentioned under section 128. A guarantees to B the payment of bill of exchange by C, the acceptor. Okay. The bill is dishonored by C. A is liable not only for the amount of the bill, but also any interest and charges which may have become due on it. That means, I am giving an easy example of this. There is a person A, there is the another person B. A has done the agreement with B that C will pay the amount of 5,000 rupees to B for a specific product receipt or for some specific kind of the services which he or she has taken from B. Okay. So when there is the specific performance of the contract, and A is promising over here to B that yes, I am going to pay you the amount of 5,000 of the rupees, then what is happening over there? In that specific circumstances, there must be the present of the third party, that is the surety. मान लो C is the surety over there. C has given the surety that yes, if the amount of 5,000 of the rupees must need to be paid in 2 months, and if the payment is not done in 2 months, then I will be responsible to do the payment of that. Got it? So the liability of the surety is co-extensive with the principal debtor. Here it is the liability of the principal debtor to do the payment of the specific property of the 5,000 rupees in between 3 months. And the liability of the surety will also run along parallelly with the surety itself. That will run parallelly or simultaneously, or it is coextensive with the प्रिंसिपल डेटर. इसका मतलब ये है कि प्रिंसिपल डेटर का उस अमाउंट को चुकाने का जितना रिस्पॉन्सिबिलिटी है, सिक्योरिटी का भी उतना ही रिस्पॉन्सिबिलिटी है. ऐसा नहीं है कि पैसा तो प्रिंसिपल डेटर ने लिया था ना 5,000 रुपया, तो सिक्योरिटी का इतना सरदर्द क्यों हो रहा है? नो, यहाँ पे सिक्योरिटी जो है ना, हीज एग्रीमेंट इज को एक्सटेंसिव. जितना दिन तक प्रिंसिपल डेटर के सर पे टेंशन रहता है टू डू द रिपेमेंट और टू डू द पेमेंट ऑफ स्पेसिफिक अमाउंट, उतना दिन तक रिस्पॉन्सिबिलिटी सिक्योरिटी का भी एक्सटेंड करता है. गॉट इट? Because in case where the principal debtor is unable to pay, जब principal debtor के पास पैसा नहीं होता है, मान लो the 2 month amount due is completed, the principal debtor is unable to do the payment, and here the responsibility goes to whom? To the surety. And here the surety is not only liable to pay the debt or pay the specific amount only, he is also liable to pay any interest arised from that property. For example, the amount must need to be paid up in between 2 months. If there is non-payment of the due, then उसी के ऊपर इंटरेस्ट लग जाते हैं, उसी का अमाउंट बढ़ जाता है. 1% इंटरेस्ट, 2% इंटरेस्ट, मान लो इंटरेस्ट लग जाता है उसी पे. The surety is also responsible or liable to do the payment of the interest of the property. That is called the liability of the surety to do the payment of specific things. Then section 129, it speaks about the continuing guarantee. A guarantee which extends to a series of transactions is called a continuing guarantee. Extends to not only one transaction, but it continues to the series of the transaction, from transaction 1 to transaction 2 to transaction 3. Then it is called the continuing guarantee. The guarantee is being continued, is stretched. Okay. For example, I have done a promise to you, promise of the surety, that whatever ingredients you are buying in this 1 month, I am going to do the payment of it. Okay. So when you are buying certain ingredients, certain goods, certain things for yourself in this 1 month, then yes, I am liable and I am responsible to do the payment of it. But here, just take an example that I am continuing my guarantee. I am telling you that not for 1 month, for 3 months. This is the duration of the 3 months. In between 3 months, whatever payment you are doing, whatever things you are buying, whatever agreement you are doing, I am responsible to pay everything on behalf of you. And I am here standing as a surety of yours. So here in the whole 3 months, whatever activity I will do, if I am unable to do my payment, then you are the person as the surety is responsible, is liable to do the payment, and you are bound to do that. You cannot deny that. You cannot escape from doing the payment. Got it? That is called the continuing guarantee. When the guarantee is not getting completed through one action, you are buying the things for the one time and I am doing the payment for it. If you are unable to do the payment, then the guarantee is not getting over there. It is continuing, it is continuing, it is continuing. ये चल रहा है. 1 महीना चला, 2 महीना चला, 3 महीना चला, जब तक एग्रीमेंट खत्म नहीं हो जाता. That this is the duration till when I am continuing my guarantee. I am continuing or I am stretching my agreement. That is called the continuing guarantee. बट मान लो आई हैव डन द एग्रीमेंट फॉर द 1 मंथ कि 1 महीने के अंदर आप जितना सामान ऑर्डर करोगे आई विल पे फॉर दैट इफ यू आर अनेबल टू डू द पेमेंट. So you are unable to do the payment and I paid for that. एक महीने के बाद when the second month started, you ordered something more. आप और कुछ सामान ऑर्डर किए. So tell me, am I responsible to do the payment of the things which has been delivered in that second month? The answer is no. I'm not liable, I'm not responsible to do the payment of the things which has been arrived in the second month because there was the pre-fixed agreement of yours with me. आपके साथ मेरा पहले से ही ये agreement होके रखा था कि whatever you will bring in 1 month, I'll payment for that 1 month only. मैं एक महीना का ही पेमेंट करूंगी, उससे ज्यादा का पेमेंट मैं नहीं करूंगी. ये चीज हम लोगों ने ऑलरेडी डील कर चुके हैं. बट अगर मैं यहाँ पे गारंटी कंटिन्यू कर देती हूँ, मैंने बोलती हूँ कि नहीं 1 महीना का नहीं, 3 महीना तक मैं एक गारंटी कंटिन्यू कर रही हूँ, तो 1 महीने के बाद दूसरे महीने जो भी सामान आप खरीदते हो उसके लिए भी मैं पे करती हूँ, तीसरे महीने जो सामान खरीदते हो उसके लिए भी मैं पे करती हूँ. हियर द गारंटी इज एक्सटेंसिव, इज कंटिन्यूइंग, इज स्ट्रेचिंग इन नेचर. दिस इज कॉल्ड द कंटिन्यूइंग गारंटी. देन Section 130, it speaks about the revocation of the continuing guarantee. A continuing guarantee may at any time be revoked by the surety as to future transaction by notice to the creditor. That means when the surety feels that the surety is unable to continue the guarantee on his behalf, then that may be revoked by the surety as the future transaction by notice to the creditor. That means you will pass a notice to the creditor that I am unable to uh, continue the surety of this, then I am passing my surety for this. There must be the notice up to the creditor that yes, I am not with the principal debtor anymore to give the surety. Okay. Okay. So, but when the principal debtor in a course of a transaction has already paid for something, has already decided to pay for something and has already promised for something, he cannot deny his responsibility in that case. For example, there is a agreement between you and me that at first we are going to I have delivered you certain things for which you are responsible to pay me the amount of 5,000 of the rupees. Okay. And as the surety of yours, there is a person C who has been appointed as the surety, and C has given me the promise that C is going to pay me the amount of 5,000 of the rupees in case you fail to pay it. Okay. अगर आप मुझे 5,000 पे नहीं कर पाते हैं तो उसका पेमेंट कौन करेगा? सी करेगा. ये सियोरिटी उसने मुझे दे दिया है. ओके, फॉर द स्पेसिफिक अमाउंट ऑफ द गुड्स. बट एंड द सियोरिटी एंड जो आपका सियोरिटी है सी है, उसने बोला कि मैं इस चीज का नहीं, इसी के आगे भी अगर कुछ सामान आप खरीदते हो तो उसी के लिए भी मैं सियोरिटी बन के रहूंगा. ओके, सो आई गॉट टू नो ओवर हियर दैट सी इज योर सियोरिटी, नॉट फॉर द स्पेसिफिक वन गुड बट फॉर द अदर गुड्स. जितना भी सामान आप मुझसे खरीदोगे उसका सियोरिटी कौन रहेगा? सी रहेगा. अगर पैसा आप नहीं भरते हो तो मैं किससे पैसा उठाऊंगी? सी से उठाऊंगी. ये हो गया हमारा पहला एग्रीमेंट. ओके, बट मान लो सी इज रिवोकिंग हिज गारंटी. सी यहाँ पे मेरे को एक नोटिस भेजता है. आई एम द क्रेडिटर ओवर हियर दैट सी इज टेलिंग मी दैट मैम, आई डोंट वांट टू कंटिन्यू विद द सियोरिटी ऑफ दिस पर्सन and I am revoking my surety over here. Okay, so yes, when C is sending a notice of the revocation to the creditor and the creditor is accepting it, that will be considered as the revocation of the surety. Then in that case, I will tell you, find the another surety who will agree to pay on behalf of you. Then only I am going to deliver the goods to you. Then this is your responsibility to find find a other surety. But yes, the surety which he has already decided to pay, that is the first amount of the delivery. पहले जो आपने मुझसे सामान लिया था उसका जो 5,000 था उसका अमाउंट आपको पहले से पे करना था. उसी के बाद ने आपने बोला कि नहीं मैं अपना सियोरिटी को रिवोक करती हूँ. बट उसके पहले का जो 5,000 आपको पे करना था, विल यू बी एक्सक्यूज्ड फॉर दैट? द आंसर इज नो. You have to pay the amount of 5,000 rupees which you have promised before. आपने पहले जो 5,000 देने का प्रॉमिस किया था वो आपको देना ही पड़ेगा. उस चीज का सियोरिटी से आप अपने आप को रिवोक नहीं कर सकते. बट येस, द लैटर सियोरिटीज जहां पे आपका सियोरिटी कंटिन्यू हो रहा था, उसके बाद दूसरा कोई चीज के लिए आपको सियोरिटी देना है, तो वहां पे आप मना कर सकते हो कि नहीं, मैंने एक चीज पे सियोरिटी दे दिया या पेमेंट कर दिया, अब आगे मैं अपना सियोरिटी कंटिन्यू करना नहीं चाहती हूँ, एंड आई वॉन्ट टू टर्मिनेट माई सियोरिटी ओवर हियर. And after sending a notice to the creditor, you can end your surety over there. That can happen, okay? But when we are talking about the revocation of the continuing guarantee, okay, in that case it is not possible when the surety has already decided to do something, or it has been already pre-agreed or pre-decided. The amount of 5,000 rupees which the surety was supposed to pay, it was pre-decided. ये पहले से ही था, पहले से एग्रीमेंट हो चुका था, तो उस चीज को डिनाई नहीं कर सकते, उस चीज का पेमेंट सियोरिटी को करना ही पड़ेगा. बट यस, उसके बाद का जो सियोरिटी उसी के हाथ में है, इफ ही वंस or she wants, she or he can terminate the agreement of the surety, and ये बोल सकता है कि मैं ये गारंटी और ये सियोरिटी और कंटिन्यू करना नहीं चाहती हूँ. गॉट इट? देन कम्स द revocation of the continuing guarantee by surety's death. The death of the surety operates in the absence of any contract to the contrary as the revocation of continuing guarantee so far as regarded as the future transaction. This is very simple. Then that when there is the death of the surety, जब surety का मौत हो जाती है, जब surety ऊपर चला जाता है, when the surety is dead, so what happens in that case? The absence of any contract to the contrary as the revocation of a continuing guarantee so far as regarded as the future of the transaction, okay? When the surety dies in that specific circumstances, even if there is the absence of the revocation of the continuing guarantee, all the future transactions by the surety is closed over there. That means with the death of the surety, its surety for all the payments or all the agreements has been suspended, revoked, closed over there. Got it? Because the death is not always comes with the notice. मौत कभी बोल के नहीं आता है, right? So when the surety dies, all the surety assurance by him also gets over with him, with his death. Got it? So then section 132 onwards we are going to discuss in the next class. This is all for today, guys. We can just drop the class over here. See you all in the next class. This is all. Thank you. Bye bye. Take care.